Well, good morning, everyone, and thank you for joining me. In the years that have followed Me Too and the introduction of the senior manager certification regime, the FCA has repeatedly stressed in speeches and publications its focus in clamping down on non-financial misconduct. And it's fair to say, I think, that there's been a lot of talk, but not a great deal of action. On the 2nd of July of this year, the FCA published its policy statement and consultation on non-financial misconduct. And in it, the FCA confirmed that it was updating its rules to better capture non-financial misconduct and explained that the aim of the changes is to give firms confidence to take robust action against serious misconduct, to drive consistency across the financial sector, and to make it clearer when non-financial misconduct is a breach of an FCA rule. And that's all part, excuse me, of the FCA's strategy for 2025 to 2030 to promote healthy and inclusive workplace cultures and to deepen trust in financial services. In this webinar this morning, I'm going to begin by looking at the new rule for non-banks, which will come into effect on the 1st of September 2026. Moving on to then look for both banks and non-banks when non-financial misconduct will breach the conduct rules and impact on fitness and propriety. And I'm going to end by looking at the impact of the FCA's proposals on workplace investigations. Given the number of people we've got on this morning, I think you're all muted with a possibility or with no possibility of unmuting. But if you do have any questions, particularly at the end, do please put them into the chat bar. I'll try and keep an eye on the chat bar in case anyone has a burning question as we go along, but otherwise we'll try and leave some time at the end. So, as things currently stand, there is no legal or formal definition of non-financial misconduct. The FCA handbook contains no express definition, and thus far there hasn't really been any clear guidance as to how the FCA defines non-financial misconduct and when it considers it to be a regulatory matter. And if one looks at COCON, the source of the Code of Conduct source book, all the examples of conduct which would be a breach of the conduct rules relate to financial misconduct, such as mis-selling, market abuse, and rate fixing. And the same is true of the guidance in relation to the fit test. All the factors identified as relevant to assessing fitness and propriety focus on financial misconduct. In 2018, Christopher Woolard, who was then Executive Director of Strategy and Competition, stated that non-financial misconduct is misconduct, plain and simple. Well, life is seldom that plain and simple, is it? Nor is non-financial misconduct, which deals with shades of human behavior. So I'm slightly distracted. Every now and then someone tells me that they're an AI assistant. So hello, AI assistants. Anyway, on a very basic level, non-financial misconduct covers any misconduct that is not financial misconduct, and it encapsulates a wide range of behaviours and actions such as bullying, sexual harassment, discriminatory behaviour, and criminal behaviour. And because non-financial misconduct is such a broad concept, and because of the lack of guidance, it's been extremely difficult for regulated businesses and individuals to know at what point non-financial misconduct becomes not just an employment matter to be dealt with internally as between the employer and employee, but a regulatory matter. And the result has been an inconsistency in determining the appropriate sanction from a disciplinary perspective and in knowing when and what to report to the FCA. Now, in September 2023, the FCA published a a chunky 131-page consultation paper looking at non-financial misconduct and setting out its proposals for all firms to better integrate non-financial misconduct considerations into their senior manager and certification regime. The proposals were said to support the FCA's aim of promoting healthy and inclusive workplace cultures and reducing the risk of groupthink within the financial services sector. And the express objective of the proposed changes was to establish minimum standards, to give firms a better understanding of regulatory expectations, and to contribute to greater consistency and transparency on approaches to diversity and inclusion across the financial services sector. A year later, at the end of September 2024, the FCA announced at its AGM that the final rules for the consulted upon changes would be announced before the end of 2024. That date was then pushed back to June 2025, and things went very quiet until 2nd of July, when the FCA issued a short policy statement publishing a rule change and published a further consultation paper. And the paper includes proposed changes to COCON and FIT sections of the handbook and reflects the feedback generated by the previous draft guidance, including removing some of the vaguer and more difficult to understand language that had been included in the earlier consultation. The consultation closed 8 days ago on the 10th of September. And one of the stated aims of the consultation was to allow the FCA to identify whether regulated firms consider that additional guidance in COCON and FIT is in fact needed to support them to apply the FCA rules consistently. And they say that that guidance will only be taken forward if there is clear support for it. And we are told that the final regulatory approach will be published before the end of this year. And let us hope that the FCA's timeline is now more reliable than it was back in 2023. And frankly, let us also hope that guidance is published and that it does reflect feedback provided during this consultation, because there really is still a need, it seems to me, for clarity and clear guidance if firms are to be comfortable about the FCA's approach and dealing with non-financial misconduct consistently. Now, historically, the application of COCON to non-banks has been narrower than for banks. And broadly speaking, COCON is always applied to conduct rule staff in banks when they are performing tasks for their employer, whether or not those tasks are part of the bank's regulated activities. In the case of non-banks, however, non-financial misconduct was only within COCON if it was part of or for the purpose of the firm's SMCR financial activities, which broadly means it's regulated activities or activities carried on for the purposes of or in connection with regulated activities. Now, with effect from the 1st of September 2026, a new rule will come into force, which will broaden the circumstances under which non-financial misconduct can be caught by the FCA's conduct rules in non-banks. And the new rule applies to all firms with Part 4A permission under the Financial Services and Markets Act 2000, which is about 37,000 firms. Under the new rule, conduct will be in scope if it occurs in any part of the business that involves SMCR financial activities. So whereas before, conduct would be in scope if it formed part of or was for the purpose of the firm's SMCR activities, with effect from the 1st of September 2026, conduct will be in scope if it occurs within the part of the firm's business that carries on regulated activities or other SMCR financial activities, regardless of whether it occurs in the context of regulated or unregulated tasks. So aligning that situation to the situation in banks. And where a firm carries on different businesses, some of which involve SMCR financial activities and others of which do not, conduct will only be in scope if it occurs in the part of the business that involves SMCR financial activities. So what does that mean in practice? Well, imagine you've got a firm's HR department that covers the entire workforce without separating the parts that deals with the firm's financial services business and another business. And the activities of someone who works within that HR function that covers the entire workforce, well, that would be within scope of COCON. If, however, the firm has an HR function that deals with those working in its financial services business and a separate HR function dealing with the other non-financial services parts of its business, conduct will be outside the scope of COCON if the conduct rule staff member committing the misconduct and the subject of the misconduct work only in the part of the HR function that doesn't deal with the financial services business but deals with the other business. Now, under the new rule, there are only certain kinds of conduct that will be in scope of COCON, and that is expressly identified as unwanted conduct towards an individual that has the purpose or effect of violating that individual's dignity or of creating an intimidating, hostile, degrading, humiliating or offensive environment for that individual. And for these purposes, the recipient of the unwanted conduct, the individual, is not limited to direct colleagues, but it can also include other group members or personnel that are providing other group members, or personnel that are providing services to the firm, such as contractors. So much broader than just a direct colleague. As with the Equality Act definition of harassment, and of course you'll have seen the wording on the slide is very similar to what we know and love with the Equality Act definition, when considering whether conduct is the kind of conduct caught by the new rule, the guidance makes clear that regard must be had to all the circumstances of the case, how the individual says the conduct made them feel, so their perception, and whether it was reasonable for the conduct to have that effect. Now, there are a few things to notice about this new rule. Firstly, it is not retrospective. It comes into effect on the 1st of September 2026 and applies thereafter. Firms are under no obligation at all to go back and look at non-financial misconduct that occurred prior to 1st of September 2026 to apply the new rule. The second thing to notice is that the new rule is the only express definition of non-financial misconduct that we've got in the rules or the handbook. And that's a bit odd and a bit frustrating, because the FCA has stated that this new rule ensures, and I quote, alignment of the treatment of bullying, harassment and violence for non-banks with that in banks. Well, banks are not subject to the new rule. And this wording is not to be found in any of the existing rules that apply to banks or indeed expressly in the guidance. Now, the FCA says it plans to address this through its proposed guidance by explaining that banks should follow the guidance on the new rule as if it applied to them. Fine, but it really is unclear why the FCA has simply not applied the new rule to all regulated firms. And it is a tad frustrating for those of us looking for clarity and consistency. The other thing to notice is that, as I said, and you can see, the definition of non-financial misconduct mirrors the definition of the Equality Act definition of harassment, loved by all of us discrimination lawyers. But there is one important difference. The unwanted conduct is not limited to conduct related to protected characteristic. And according to the FCA, the regulatory regime is not limited to protected characteristics, but is intended to address wider forms of misconduct, which the FCA considers relevant to its statutory objectives. And the FCA's stated aim is to make sure that firms address serious misconduct robustly and consistently and prevent perpetrators from causing further harm. And it's important to remember when looking at non-financial misconduct so that it isn't limited to a protected characteristic. So, for example, if you are looking at unwanted conduct that an individual says it has caused them to feel as if their dignity is violated, and the individual says it's because I'm working class, or because I'm short, or because I'm fat, that is not necessarily a claim that's going to get them into an employment tribunal arguing discrimination, but it is something that might fall within the regulator's purview if it is found to be established. So what then is the case in relation to other forms of non-financial misconduct in non-banks? So misconduct that doesn't fall within the definition that we have got in the new rule. Well, of course, and by other non-financial misconduct, I mean, for example, well, it could be anything: stealing from colleagues, being under the influence of drugs or alcohol at work. Well, clearly such misconduct would still be a matter to be dealt with in accordance with the firm's own internal disciplinary policies and procedures and employment law. It could, excuse me, still become a regulatory matter because under the other provisions of COCON, it could still be a breach of a conduct rule if it was part of or for the purpose of the firm's SMCR financial activities. So effectively the COCON as it originally stood. But that is a threshold that it's unlikely to be met in many cases. But in any event, regardless of whether it breaches the conduct rules, any form of non-financial misconduct may be taken into account when assessing an individual's fitness and propriety. And so the point is, just because the non-financial misconduct allegation that a firm is dealing with doesn't fit within the new rule, of course, it doesn't mean that it's not the potential to be a regulatory matter. In the case of banks and non-financial misconduct, as I said previously, the FCA's position is that the new rule ensures alignment of the treatment of bullying, harassment, and violence for non-banks with that in banks. And therefore, although the new rule doesn't apply to banks, they should follow the guidance on the new rule as if it did apply to them. Now, when will non-financial misconduct be a breach under COCON? The proposed draft guidance, which, as I said, is for all firms, both banks and non-banks, offers a non-exhaustive framework for determining whether non-financial misconduct falls within the scope of COCON. And it is clear from the guidance that conduct which occurs in an employee's private and personal life is outside the scope of COCON. So it cannot amount, if found proven, to a breach of a conduct rule. It is equally clear, however, that conduct which falls outside the scope of COCON may still be relevant to an assessment of fitness and propriety, and thus relevant to whether or not a senior manager or certified individual, somebody to whom the fitness and propriety rules apply, is relevant to whether or not they are competent and capable of doing their job and may be regulated as such. Now, looking at the relevant factors to be considered in determining whether non-financial misconduct falls within the scope of COCON, it's clear that the context of the behaviour is key. So broadly speaking, the focus is on where, when, how, and between whom it occurred. Recognizing, I think, how difficult it can be to draw the boundary between private and professional conduct, the consultation paper includes some examples, some case studies to help firms identify the sort of conduct which would likely to be in scope and that which would likely to be considered out of scope. So in-scope conduct, according to the guidance, is likely to include misconduct by a conduct rule staff member in relation to a colleague while both are on the firm's premises, misconduct by a conduct rule staff member towards a colleague while the staff member is working remotely for the firm, or while both are travelling to a meeting in which they'll represent the firm, or at a social occasion organised by the firm. And it will also include misconduct by the individual at a business meeting where the individual is representing the firm, or at an event organised by the firm, a client, by another firm, an industry body or a regulator where the individual is representing the firm, or whether their work for the firm is the main reason for the invitation. So we're looking at things like a meeting, work-related social occasions organised by a client, a round table, an award ceremony, a training course, or a workshop. According to the guidance, if, however, while working remotely, a conduct rule staff member is seen or heard doing or saying something rude or offensive to a family member or another individual, third party, rather than a work colleague, that will not be in scope. It does seem to me, however, that must rather depend on the circumstances, what is done to the family member or third party, and the circumstances in which it is observed. Because one can imagine a scenario where a work colleague observes an individual doing something online towards a family member or third party, which they regard as being offensive and which causes them to feel humiliated. And there are, of course, still, as there are now, going to be potentially difficult cases where it's difficult to draw the line between work and private life. And from a firm's perspective, the critical issue will be in analysing the connection to an individual's professional life. And broadly speaking, if it's easy to identify the connection to the individual's work, then the conduct is likely to fall within the scope of COCON. However, if no connection can be drawn, or drawing a connection requires a strained interpretation, then it's likely that the conduct is outside of work and is outside of COCON. And on a practical level, in those cases where the line between work and private life is difficult to draw, it would be sensible for firms to document their determination, articulate the reasons for their determination so it can justify its approach in due course. The draft guidance now specifically addresses the use of social media, including messaging apps. Now, the FCA recognises that employees are entitled lawfully to express views, even if they are controversial or offensive, without calling their integrity or fitness and propriety into questions. And factors to take into account when deciding whether material published on social media fall within the scope of COCON include the matters that I've set out on the slide. So whether the material is directed towards a colleague, or whether there is another connection between the poster of the material and the subject of the misconduct that is not based on either's work with a firm, whether it's part of a course of conduct that includes other incidents that are more closely connected with the individual's work at the firm, whether the content of the post is related to work at the firm, and whether a work issued device was used or the conduct took place over the firm's systems. And of course, that would include use of the firm's email systems. However, the fact that posts were uploaded during working hours or on the firm's premises is of limited relevance to determine whether there is a sufficiently close connection to work to mean that it could fall within scope of COCON. Even if it's determined, of course, that social media posts do not fall within COCON, they may still be relevant to fitness and propriety. If, for example, they demonstrate a real risk that the person will breach the requirements of the regulatory system or show a willingness to disregard ethical or legal obligations. And I'm going to come back to look at what factors are relevant for fit in a moment. And again, it may be that there are some clear-cut cases where social media activity includes criminal activity. But there are likely to be, I think, far more cases where the matter is not so clear. And firms are really going to have to think about and work out at what point it can be said that a post has strayed into territory where it might be seen to be disregarding ethical obligations. And I'm talking here about posts that are on a private WhatsApp and appear on their face to be entirely unrelated to work. For example, would a post that a colleague reads and regards as sexist or misogynistic, can that be said to demonstrate a willingness to disregard ethical or legal obligations because it is in breach of the Equality Act, and therefore it ought to be taken into account when assessing the individual's fitness and propriety? Difficult questions, the answer isn't clear. Turning to specific conduct rules themselves, which are likely to be impacted and relevant for the purposes of non-financial misconduct. Individual Conduct Rule 1 is, of course, the requirement that individuals act with integrity. And according to the proposed guidance, there'll be a breach of Individual Conduct Rule 1 where an individual subjects others to a detriment for using the firm's whistleblowing procedure, or for complying with Individual Conduct Rule 3. That's the rule which states that individuals must be open and cooperative with the FCA, the PRA, and other regulators, or where the individual subjects another to a detriment for complying with Conduct Rule 4. And actually, forgive me, rather than ICR 4, that the slide should read Senior Manager Conduct Rule 4, so SM4. And that's the conduct rule which requires senior managers to disclose appropriately information of which the FCA or PRA would reasonably expect notice. And this is new in the guidance, and it's making express that subjecting an individual to a detriment for blowing the whistle or complying with Individual Conduct Rule 3 or complying with the Senior Manager Rule 4, all requirements of that require individuals to communicate something of importance to the regulator, then subjecting someone to a detriment for that is a serious matter as far as the FCA is concerned and would amount to a breach of the conduct rules. Outside of that, for non-financial misconduct to amount to a breach of Conduct Rule 1, it must be serious and it must involve a lack of integrity. Turning first to the question of, of seriousness, the guidance sets out a list of factors for firms to take into account when determining seriousness. And they include whether the conduct is part of a repeated pattern of behavior or has gone on for a long time. It also looks at the seniority of the perpetrator and any disparity with the seniority of the subject, including whether the perpetrator has influence over the subject's career, whether the subject has specific characteristics or vulnerabilities, particularly if that is a factor in the conduct in question, whether the perpetrator has previously been warned or disciplined for similar conduct, and whether they've previously undertaken not to carry out the conduct in question, whether the conduct is criminal or would justify dismissal. And also relevant, an aggravating factor which can impact on the seriousness of non-financial misconduct and make it serious enough to fall within COCON. It is the impact of the conduct on the subject or a witness to the conduct. So the subjective view of the subject of the conduct or a witness to the conduct is a relevant factor in determining seriousness. It's an aggravating factor. However, according to the FCA, whether or not the non-financial misconduct has been the subject of a formal complaint will not generally be regarded as relevant to the question of seriousness, and also the mere fact that the conduct in question is in breach of a staff handbook or another internal policy which the perpetrator had undertaken to comply with. Again, that's unlikely to be a matter of great significance. The problem with this really is that the FCA proposes a test which on the face of it sounds quite simple. Is the conduct serious? And the answer is binary. Either it's serious or it isn't. However, as the multiple relevant factors identified by the FCA in the guidance indicate, it's likely to be really hard for firms to determine when conduct is serious, because there's likely to be a spectrum of seriousness, and determining where on the spectrum the allegation falls will require really careful and indeed documented analysis, again, so it can be justified to the regulator or indeed to individuals at a later date. Turning to the second requirement of integrity, conduct will only lack integrity if it is deliberate or reckless. And the guidance provides that there will be no breach of Conduct Rule 1 if the perpetrator thought that there was good and proper reason for the conduct and its effects were proportionate to the intended aim of the conduct, or they didn't intend to have a negative impact on the subject of the misconduct, they didn't know they were doing so, and were not reckless about the effect of their conduct. So in a way, this is kind of a get out of jail free card for the individual who thought that what they were doing was in effect okay. The belief, however, must be reasonable, and an unreasonable belief that conduct is justified can in itself show a lack of integrity. And for example, it's going to be really difficult, it seems to me, for an individual to demonstrate that they have a reasonable belief that their conduct was justified in the manner set out on the slide if there have been repeated instances of the same misconduct, or if they've been previously warned about their behavior, either formally via an internal process or because someone has complained to them about their conduct and how it makes them feel. And in those circumstances, as I said, it's going to be very difficult to demonstrate that their belief that their conduct was justified and proportionate was reasonable. The second individual conduct rule is the requirement to act with due skill, care, and diligence. And what's interesting from the guidance is it really raises the bar for managers. And in this context, when I use the word managers, I'm referring both to senior managers holding senior management functions within FCA regulated firms and small m managers who are subject to the conduct rule. And in broad terms, and according to the guidance, managers may breach the requirement to act with due skill, care, and diligence if they know that non-financial misconduct is taking place or willfully stick their head in the sand and, in either case, fail to intervene to stop it, or if they fail to operate policies, systems, and controls appropriately to detect non-financial misconduct, or assuming that the manager has the authority to do so, the manager fails to set up and maintain policies, systems, and controls that are appropriate to detect non-financial misconduct. Equally, a manager may find themselves in breach of Conduct Rule 2 if they fail to take reasonable steps to provide a safe environment for people to raise concerns about such treatment. So fail to operate a speak up policy and enforce a speak up and encourage a speak up culture. As we saw with Conduct Rule 1, the knowledge and thought process of the manager is relevant. So there'll be no breach of Conduct Rule 2 if the manager thought that the perpetrator's conduct would have no ill effects on the subject, and a reasonable person with the skills that the manager in question has or ought to have would have thought the same and would have thought the conduct was justified. There is certain conduct, and I'm now moving on to look not at COCON, but at the fit and proper test module of the handbook. There is certain conduct that the FCA has identified will always be relevant to an assessment of an individual's fitness and propriety, whether it occurs inside or outside of work. And that is dishonesty, offences of violence, sexual offences, or offences related to a person or a group's demographic characteristics, such as racially motivated or aggravated offences, whether or not they occur in the UK. Interestingly, the proposed guidance says that even if a breach of a law would not otherwise be relevant to an assessment under fit, because it's minor, repeated breaches may raise doubts as to whether the individual will follow the requirements of the regulatory system. And an example given in the guidance is this. Thus, says the guidance, for example, a minor driving offence will not normally be relevant to fitness and propriety, but frequently repeated such offences may be, from which one assumes that the FCA owns shares in line bikes. Other cases, other than dishonesty, violence, etc., are going to be more difficult, it seems to me, to determine. According to the FCA, conduct in an individual's private and personal life may be relevant to an assessment of their fitness and propriety, even if there is little or no risk of it being repeated in their work for the firm. And that is likely or may be the case if it breaches the requirements of the regulatory system or demonstrates a willingness to disregard ethical or legal obligations, abuse a position of trust, or exploit the vulnerability of others. It may also be so serious that to allow the individual to continue to work in a regulated role would undermine public confidence in the regulatory system. So whereas with COCON, whatever happens in an individual's private and personal life is outside scope, it's very much in scope when it comes to fitness and propriety. Now, the proposed guidance confirms that firms are not expected to monitor employees' private lives, but they should investigate if there is good reason to do so. For example, when the firm becomes aware of an allegation which, if true, would call the individual's fitness and propriety into question. The FCA recognises that a firm might have a limited ability to investigate, and that there might be circumstances where it is better to leave an investigation to the authorities or the police, for example. But the FCA is clear in its guidance that firms are expected to consider, at the very least, what steps it can reasonably take to investigate and assess the possible impact of an allegation on fitness and propriety. And that might simply include informing the individual what has come to the firm's attention and asking for an explanation. So if the firms become aware of an allegation of non-financial misconduct in an individual's private life, they can't just ignore it. They have to at least consider what can we do to investigate it. An alarming thing, though, to note from the guidance is that it suggests that firms may need to consider making a report to the FCA, even where it has not been able to establish the truth of an allegation in non-financial misconduct occurring in private life, if the allegation, if established, would reasonably be material to an assessment of fitness and propriety, if true. Now, I really struggle with this bit of the guidance because I struggle to see how it can be appropriate for a firm to report entirely unsubstantiated allegations to the FCA, and helpfully, the guidance doesn't provide any clarity on that point. So where does that leave us in relation to workplace investigations? It's important to understand that the purpose of the FCA's new rule and proposed guidance is not to change employment law or practice, but to determine the regulatory consequences of certain conduct or behaviour. Having said that, while the FCA's rules, guidance and employment law are distinct and have their own consequences, they do overlap and impact on one another. So while the FCA's proposals don't dictate how workplace investigations are to be conducted, they will have to be considered throughout an investigation into alleged non-financial misconduct, including when it comes to considering sanctions that follow any finding of non-financial misconduct. And when allegations of non-financial misconduct are made, it's essential that HR, legal, and compliance work together and have a clear understanding of COCON and FIT and the issues that will need to be considered. And non-financial misconduct really can't any longer be considered to be just an HR matter. When an allegation of non-financial misconduct is made, HR, legal, and compliance are really going to have to work together to analyse the risks and identify what needs to be investigated, what sort of investigation needs to be run, how it is to be conducted, and what needs to be recorded and reported and to who. And to an extent, when questionable conduct has occurred, firms to date have had a discretion as to whether it warrants disciplinary action. Going forward, firms really aren't going to be able to ignore the FCA's guidance as to what is significant from a regulatory perspective. Arguably, this limits firms' discretion, or at least suggests that firms should think extremely carefully before concluding that investigation and disciplinary action is not warranted, and document the thought process. Thinking back to the questions posed in the FCA's 2024 survey, which sought information in relation to non-financial misconduct complaints, investigations, and outcomes, firms should ensure now that they have proper systems in place to record allegations of non-financial misconduct and to record allegations and ensure that sufficient information is shared with relevant senior managers and the board. And I think in terms of the purpose of any investigation for non-financial misconduct, that it's really twofold. Firstly, to identify whether the conduct in question was misconduct from an internal HR employment law point of view, and secondly, to establish whether there's been a regulatory breach. As such, any investigation into non-financial misconduct should sensibly include all the factors identified as relevant in COCON and FIT. For example, careful thought is going to have to be given to the scope of the investigation and the terms of reference to ensure that it's wide enough and asks the right questions. So, for example, the scope will need to identify the type of conduct alleged, the context of the conduct. Did it, for example, take place in circumstances that bring it within the scope of COCON or FIT? Was it in work, or was it outside of work in the employee's personal and private life, but there are factors which mean it may be relevant to an assessment of fitness and propriety? What steps can be taken to investigate that conduct? What's the impact of the conduct on the subject and any witness to the conduct? What was the perpetrator's knowledge and belief? One will also have to include within the scope questions of seriousness. Was the conduct serious? Could it demonstrate a lack of integrity? All relevant factors will need to be considered, and which must form part of the investigation and the terms of reference. And the terms of reference are really going to have to ask all the right questions of the investigator to ensure that the investigation covers all relevant material and matters. And at the end of the investigation, there are going to have to be findings made in relation to all relevant COCON or FIT matters, which will need to be, of course, clearly articulated in any investigation report and disciplinary decision that follows. By the same token, individuals accused of non-financial misconduct who find themselves the subject of an investigation will really need to focus their defence so that it specifically covers their position on matters identified as relevant in the guidance. For example, is there context, which means that the conduct, if it happened, was not a workplace matter? Is the conduct not serious? Did the individual have a reasonable belief that there was good and proper reason for their conduct? All matters that an individual who finds themselves the subject of an investigation should prudently deal with in their evidence. Another reason, of course, for HR, legal and compliance to be aligned when allegations of non-financial misconduct arise is that there may be reporting obligations even before any internal investigation has been completed. However, when the decision is taken to inform the regulator of the fact of an investigation into non-financial misconduct, care should be taken to ensure that appropriate context is provided. And a failure to be measured and accurate when reporting to the FCA could give rise to a breach of trust and confidence and expensive breach of contract claims from employees who claim to be the victim of an inaccurate and or a misleading report. Firms must also ensure that they have a clear understanding of when reporting obligations are triggered in instances of non-financial misconduct. And I'd suggest that it would be wise to record decisions taken to report or not to report, articulating the reasons for decision. Will Clayton, I can see, has asked whether there have been any changes to the guidance on when individuals ought to self-report their own non-financial misconduct to their regulated employers or to the FCA. Well, clicked the wrong button. Not insofar as COCON is concerned. However, arguably in relation to fitness and propriety, when one is looking at the sort of matters that could be relevant to fitness and propriety, if there is conduct to which an individual has that an individual has committed, either at work or in relation to their private or personal life, and that individual knows or ought to know that it impacts or has the potential to impact on their fitness and propriety, then that is likely to be a matter that the FCA would consider ought to be reported. And that's generally speaking in the case of ordinary managers, because of course there's Senior Manager Conduct Rule 4, which requires senior managers to disclose appropriately any information of which the FCA or PRA would reasonably expect notice. So there's no express provision, but arguably far more falls within SMCR 4 than had been previously. Elaine, that's a really good point that I was about to come on to. As Elaine Ahrens, thank you, that given the potential consequences for individuals, is it arguable that investigations have to be run in line with the rules of natural justice, etc.? I think absolutely that is right, because, and I think what we're likely to see, as we've seen in other regulated sectors, such as healthcare and education, that increasingly individuals will ask to be accompanied to investigation meetings and disciplinary meetings, because the outcome of those meetings could impact on their regulated status. And the seriousness, the consequences are, as you say, so serious that it really is incumbent on firms to ensure that they are dealing with investigations in a way that really is compliant with natural justice. And if they don't, they're likely to increasingly find themselves at the wrong end of potential injunctions to ensure that a proper process is followed, or expensive breach of contract claims and allegations of fundamental breaches of trust and confidence. Just one other point to think about is that to date, financial services employers have often been comfortable in treating a bullying complaint as just an issue between two employees that can be treated under normal internal disciplinary or grievance processes. However, if looking at the guidance, bullying and harassment are now regarded as non-financial misconduct, which falls within the regulatory regime because they're behaviours that are relevant to the proper operation of the UK's banking and finance sector as a whole. The public interest is clear, which may mean that there is increased scope for a disgruntled employee to make some allegation around bullying or harassment and then allege that their allegations amount to whistleblowing and any subsequent employer conduct which displeases them as retaliation. So when a non-financial misconduct allegation is made, firms are going to need to consider whether it engages a whistleblowing procedure, which is likely to entail additional procedural requirements. For example, anonymity for the complainant or retaliation monitoring. It may also, of course, no longer be enough simply to investigate an allegation made by one individual against another individual in isolation. Let's say, for example, there's been a complaint of bullying or harassment in a particular business unit by a particular manager. In addition to investigating the specific allegations, it may be necessary to investigate any managers who might be responsible for failing to prevent the non-financial misconduct. And that may mean that alongside the disciplinary investigation dealing with the specific individuals, there might also be a need to investigate or carry out some form of culture assessment or a further investigation designed to understand whether it's a case of one bad apple or a more systemic issue. It may be, for example, that a single complaint of non-financial misconduct reveals an underlying boys' club culture in which sexism or laddish behaviour has been tolerated and allowed to flourish, or where bullying has been condoned. It might reveal a failure in the firm's speak up culture, or a failure in its appraisal process, which failed to pick up the fact that a subordinate was a bully. So a single specific complaint of non-financial misconduct might identify that there are steps that need to be taken by the firm to remedy broader issues relating to corporate governance and culture, and present then a story of genuine change to the authorities. Picking up again on the point that of seriousness and impact on the individual against whom the allegations are made, I think it is important to remember that misconduct allegations can often be nuanced. And so firms should be careful not to assume that breach of an internal policy will always be a breach of a conduct rule leading to a negative fit assessment. The proposals are clearly limited to serious cases. So HR, legal, compliance, all those involved in investigations and dealing with non-financial misconduct are going to need to have a good understanding of what is serious. And even if there is a zero tolerance policy within the firm, it doesn't follow that the regulator would view the same conduct as a regulatory matter. And I think, again, coming back to Elaine Erin's question, the effect of upholding allegations of non-financial misconduct can have career-ending consequences, either because the individual is barred from working in financial services or because they are rendered effectively unemployable as a result of a negative regulatory reference. I think because of that, the rigor of an investigation is likely to be enhanced, particularly given the extent to which it's likely to be scrutinized. On the one hand, by an employee if harmful findings are made against them, and from the FCA if they are not. And the FCA says that it expects that allegations of non-financial misconduct are assessed objectively and independently by an appropriately qualified person. Now, this doesn't necessarily mean that the investigator must be someone external, but it may well be something that firms wish to consider given the potential regulatory implications for a firm that doesn't identify and deal appropriately with non-financial misconduct. And with what arguably sounds like a shameless pitch for business, given that I regularly conduct independent investigations in financial services, I'm just going to now look to pick up the other questions which have come into the chat bar. And so, Constance Shaw, you ask about the new rule not being retrospective, which means that firms don't have to revisit any conduct or decisions made in the past. How do I think firms should treat conduct which happened pre-September 2026, but which is only discovered post 1st of September 2026? I think if one is looking at the point at which the allegations come to your attention, which is after the new rule comes into effect, then it's the new rule that applies, and you would be wise to follow the guidance. The point about retrospectivity, if I can call it that, is that you don't need to go back and reopen disciplinary proceedings or reports that you might have made to the FCA, or indeed included matters in a regulatory reference, which was based on the law as you understood it at the time. But going forward, even if the allegation or conduct happened pre-September 2026, but it's only discovered post September 2026, then the new rules and guidance should apply. Dan, expanding on the circumstances in which injunctive relief can be sought, that's quite a long conversation, but broadly speaking, it is possible that an individual might apply for an injunction to pause a disciplinary process until a proper, fair process has been applied. For example, it may be that, or I could see that seeking to delay a report to the regulator in circumstances in which no investigation has been carried out and there's a questionable reason to, or real reason to doubt the information. In those circumstances, one might attempt an injunction to pause until the appropriate steps are carried out. It's quite complicated. It happens quite a lot in healthcare under the MHPS procedure. But I think in desperate circumstances where individuals in financial services are facing increasingly more problematic investigations and processes, it's something to consider. In relation to individuals being accompanied and by a legal representative, is it something that I think the firm should fund? I don't think there's an obvious reason for the firm to fund it. I also don't think there's an obvious reason for the firms to go off and encourage somebody to say that they'd like to be accompanied in a disciplinary process. I think that my point is that it is something that individuals are likely increasingly to ask about. Now, that doesn't mean, of course, that there needs to be an attempt to turn an internal disciplinary proceeding into a combative, litigious process. But I can see that there is more of a desire, perhaps, for individuals to say they want their lawyer present and able to make submissions, at least in writing. Does a COCON investigation and or rule breach determination need to be undertaken by a firm if information comes to light while the individual is in the process of leaving or has left? And does it make any difference if the individual is certified or an SMF? To an extent, it depends on the circumstance, but I think in almost every case, it's going to be inevitable that an investigation needs to be conducted, not least to determine whether or not there is any issue further up the chain in relation to a manager, for example, who failed to prevent the non-financial misconduct that is alleged, or if there's some sort of systemic issue. The regulator is pretty clear, particularly in relation to SMFs, that it is not keen at all on firms that choose to turn a Nelsonian blind eye to misconduct, particularly from senior managers. And one has to only have a read of the atrium underwriting decision, which resulted, I think, in the largest fine that was ever imposed on a firm, largely where managers had condoned misconduct and indeed allowed people or a person who was committing or had several complaints of non-financial misconduct, of serious bullying, and they allowed that individual to leave without conducting any proper investigation, and indeed allowed the individual to leave under a settlement agreement. So yes, I do think one has to still investigate if there is a potential rule breach, and of course for the purposes of a regulatory reference. If, of course, for whatever reason it just becomes impossible to investigate, then that may well still be a matter that needs to be raised under question G of the regulatory reference, albeit you would have to make clear that allegations were made and couldn't be investigated. Charlotte, I think, yes, the consequences of breach are more consequential for an individual because it can impact on their ability to work. Interestingly, the 2023 guidance proposed changes to the threshold conditions for firms, which in more obvious or express terms indicated that failures to deal with non-financial misconduct at a firm level could affect their threshold or their ability to meet the threshold conditions and be a regulated firm. That part of the guidance and the changes to the relevant section of the handbook are not going forward. And so I suppose in terms of consequences, a firm is likely to be hit by a large fine, but generally speaking, even a large fine, I suppose, is an easier pill for a firm to swallow than it is for an individual to have to swallow a loss of their regulated status. And I think picking up David Walton on a point that I made before, it's really difficult, I think, when now someone is accused of non-financial misconduct to allow them to disappear off into the sunset with a settlement agreement. And that does, to an extent, limit a firm's freedom to engage in a protected conversation or explore an agreed exit. I think it's still possible, but one would have to be very clear that it's not done in the context of being seen as suppressing an allegation, of failing to investigate it, or of condoning it. So even if the individual is allowed to leave, the firm would need to think very carefully of how it deals with the person who has made an allegation that has not been tested because somebody has left. Rachel, what's my view of whether it's necessary to have an external independent firm or entity conduct a fact-finding exercise rather than this being carried out by a law firm instructed to also advise on the law? there's the self-interested part of me, which will always say, of course, you want to have two separate entities. But less flippantly, I think it really is difficult for one firm to carry out the investigation and advise on the law, particularly when we're dealing with high stakes investigations, which are likely to be the subject of scrutiny by the FCA and also by an individual who finds himself at the wrong end of an investigation, because you're wearing two hats, and there will be open things that are open in the investigation, but also privileged advice, and it just becomes complicated. So in my view, where one's dealing with these, serious matters that have the potential to be regulatory matters, it is neater, easier, and more sensible to pick which hat you're going to wear to either conduct the fact-finding exercise or to advise on the law and the process, as it inevitably will carry on for quite some time with the FCA and the individual. David Thomas, yes, I do agree that I think there is going to be reduced scope for exiting an employee under a settlement agreement until an investigation has been carried out, because the failure to carry out the investigation is likely to suggest to individuals within the business and to the FCA that there is a faulty speak up culture, that if you speak up about misconduct, it's ignored. And that is the problem, particularly when it comes to managers and their obligations and their compliance with individual conduct rule 2. So yes, I think it's likely to remove the attractiveness of settlements from the individual's point of view. However, a full and thorough investigation could make a settlement a little bit cheaper for a firm. Charlotte, could one make payment under a settlement agreement subject to fitness and propriety findings? Yes, I suppose in theory one could say that the settlement is made, but I can't really, it's subject to fitness and propriety, and therefore if any matter comes to light later which suggests that the individual ought not to be fit and proper, then there could be some repayment provisions. The reason that I'm hesitating is it's not immediately obvious why one would delay considering the questions of fitness and propriety as part of the settlement agreement, partly for a practical reason that if you hand over shed loads of cash, the prospects of getting it back, even with litigation, is probably quite limited. Karen, how would an employer fare where its own investigation leads to a dismissal, and an employment setting there's a fair and reasonable process, but the regulatory outcome concludes there is no finding? I think it's really the same sort of position that one has if one is looking at a criminal matter, which is investigated by the police. Almost invariably, police investigations and criminal matters take so long to conclude that an employer needs to decide what it does or was going to do long before that. And the fact that a subsequent police investigation or criminal outcome, rather, a criminal hearing determines that the individual was innocent doesn't necessarily affect the unfair dismissal. So I think the same sort of thing applies. The fact that a subsequent FCA investigation may conclude that its regulatory threshold is not met, in the sense that conduct what didn't amount to a breach of COCON, and there is no reason to withdraw an individual's regulated status. That doesn't mean that the individual did not breach internal policies, procedures, the Equality Act, etc., and that a fair process was not followed to dismissal. So I don't think, as long as the employer's investigation is proper, I don't see that as being particularly problematic. Great. Well, look, I'm conscious of the time. Thank you, everyone, for joining me. This is an area which throws up all sorts of questions. Oh, sorry, I can see a couple of questions. I think we've in the Q&A bit, but I think we've covered that. So look, anyway, it is the sort of area that throws up all sorts of knotty issues, particularly because despite the FCA saying it's all going to be very clear and consistent, it really isn't that clear. There's lots of knotty issues. So you all know where I live. I'm at Littleton Chambers. You've got my email address. You've got my phone number. Do feel free to drop me a line. I'm always really happy to chat things through and bat things about. So all that remains is to say thank you very much for joining me this morning.